The subcommittee will come to order. Without objection, the chair is authorized to declare a recess of the subcommittee at any time. Without objection, members of the full committee not on this subcommittee are authorized to participate in today's hearing. Members are reminded to keep their video function on at all times, even when they are not recognized by the chair. Members are reminded that they are responsible for muting and unmuting themselves, and to mute themselves after they are finished speaking. Consistent with the regulations accompanying HRES 965, the staff will only mute members and witnesses as appropriate when not recognized in order to avoid inadvertent background noise. Members are reminded that all House rules relating to order and decorum apply to this remote hearing. This hearing is entitled Insider Trading and Stock Option Grants, an examination of corporate integrity in the COVID-19 pandemic. We know that we have votes on the floor. We will not have any further delays of this hearing in order to allow members to vote. Rather, members should go vote and return. While we all have our part of the alphabet to vote in, I'm sure there can be some accommodation made. So if it is your turn to ask questions, you can vote with others not of your same alphabetical characterization. When I'm voting, I believe Mr. Meeks has agreed to serve as chair until my return. I will now recognize myself for 5 minutes for an opening statement. Our capital market system is unique in history. Up until about 150 years ago, every business enterprise was made up of people who knew each other, who were family members, who had personal trust. And a business could only be as large as a group of people could finance and put together. And investment opportunities were limited to those that you happen to be able to know. You wouldn't trust your money with some enterprise of strangers. And of course, you didn't have liquidity since you could sell your investment pretty much only to somebody else who knew those who were in the syndicate. And so at that point, people could rely on personal trust. Today, investors turn their money over to anonymous insiders, corporate boards, and executives who they've never met. And they know that the insiders have far more information, attention, and power. And so they don't have the binds of personal trust. They rely on law to make sure that the insiders are treating the investors fairly. I'll continue. We had a little technical problem there. We now apply that system to the COVID pandemic, in which nearly 200,000 Americans have lost their lives, and in which many firms affected by this pandemic are having sudden increases or decreases in their value. Many pharmaceutical firms, for example, even the suggestion of involvement in a federal program can cause shares to shoot up in value. Following this sort of announcement, Kodak, Novavax, and Vaxart each saw their stock prices rise by over 400%. With this trend in mind, the SEC has reminded companies that in this pandemic, they should not only abide by law, but practice, quote, good corporate hygiene. Chair Clayton has reiterated these views in a recent letter regarding today's hearing, which I submit for the record and will be made part of the record without objection. But admonishments are not laws and regulations. Admonishments will not deter the truly greedy. And so we have to design our laws and regulations to govern those who cannot be governed by mere admonishments. For example, while taxpayers have invested $3.1 billion in federal contracts with Novavax and Moderna to develop vaccines, since April, executives of these firms have sold over $60 million in their company's stock. We need to know that they were not taking advantage of any inside information, that perhaps their stock had gone up too high given the realistic possibilities. Of greater concern is suspicious activity involving Kodak, with the announcement of a $765 million government loan that raised insider trader concern. In particular, we have a concern there on stock options and their grant dates. When all equity compensation to insiders needs to be approved by shareholders. When shareholders approve a plan that says that stock options will be granted with a stock option exercise price equal to fair market value on option grant date, they believe that executives who get these stock options will live by that. If instead the quote fair market value doesn't reflect not material information, insider information that's going to be announced the next day or the next week, then shareholders have been duped into approving equity compensation that does not reflect real fair market value. I want to thank the insiders at Kodak who have added insult to injury. First, they granted stock options at what they knew to be an unfairly low price. Then they spent a lot of shareholder money on a corporate law firm to tell them it was all legal. That memo tells us we've got to change the law, because if any major firm can say this is legal, it shouldn't be. And so we have to deal with the issues of what is called spring loading, where shareholders approve a compensation plan based on fair market value. It has to be a fair market value with the market when the market has knowledge of the material transactions that the insiders know about. So I look forward to exploring this with our witnesses, and we will now hear from the ranking member for 4 minutes for his opening statement.
Thank you, Mr. Chairman. It's famously been said, a definition of insanity is doing the same thing over and over again, expecting different results. So here we are once again holding a hearing on an issue that we've already held a hearing on. Additionally, 3 of these bills attached to this hearing have not only had a hearing, they've been passed by the House of Representatives. So I asked the committee, why are we spending precious time and resources on bills that have already passed the House of Representatives 9 months ago? Just because we keep having hearings on bills that have already passed doesn't mean that the Senate is going to take them up. Now, don't get me wrong. Insider trading is not only wrong, it is illegal. And not only does it hurt the integrity of our capital markets, but it also hurts our Main Street investors, as well as Mr. and Mrs. 401k. And yes, we also agree that insider trading should be and must be punished to the fullest extent of the law. However, the subcommittee should not be used as a name and shame game for companies for wrongdoing that they have perceived to have happened. And yes, the facts surrounding one company at first certainly appear to be suspicious and need to be fully investigated, but that's not our job. The Securities and Exchange Commission is tasked with ensuring market integrity, and under the Securities Exchange Act of 1934, the SEC already has the power to bring enforcement actions in instances of insider trading. In fact, during fiscal year 2019, the Commission brought 862 enforcement actions to hold individuals, issuers, financial institutions, and others accountable, sending a clear message to market participants. Last year's results speak for themselves. 862 enforcement actions obtained judgments and orders totaling more than $4.3 billion in disgorgement and penalties, obtained nearly 600 bars or suspensions against market participants, suspended trading in securities of 271 issuers, and returned nearly $1.2 billion to harmed investors. So instead of playing judge, jury, and executioner in the court of public opinion, the committee should be focused on the bipartisan solutions that support job creators of all sizes, particularly our hard-hit small businesses. These proposals would strengthen broader access to capital, reduce regulatory costs and burdens, and improve and expand access for investors to better put their money to work and create more investment opportunities for everyday Main Street investors. But now I'm not just going to curse the political darkness. I'm going to try to light a policy candle here. And here's a partial list of what we should be discussing and working on today. HR 4860, Crowdfunding Amendments Act, introduced by the ranking member. We've got my legislation, HR 609, which is the Small Business Mergers and Acquisitions, Sales and Brokers Simplification Act, something we've dealt with now for 4 Congresses in a row. HR 1909, Helping Angels Lead Our Startups, by Representative Shabbat of the Small Business Committee. HR 2899, Main Street Growth Act, introduced by Congressman Emmer. Barry Loudermilk's HR 3987, Alleviating Stress Test Burdens to Help Investors Act. HR 4076, Modernizing Disclosures for Investors Act, introduced by the Vice Ranking Member, Ms. Wagner. Another one of my bills, HR 2919, Improving Investment Research for Small and Emerging Issuers Act. Representative Stile has one on Helping Startups Continue to Grow Act. Regulation A+ Improvement Act, introduced by the subcommittee Vice Ranking Member, Congressman Hollingsworth. I could go on, but the list is, as you can see, exhaustive. And we've got much more to do. But instead of holding hearings on legislation that the House has already acted on, let's move forward on bipartisan solutions that deliver the results the American people deserve from the Financial Services Committee. We know that there are problems. We need to address those problems. This isn't going to do it, unfortunately. So
I would point out that one part of this hearing is on my bill to deal with spring loading, which has not been considered by this committee, let alone the full House, and which bans a practice that I think we'll discover is both wrongful and unfortunately legal. And so we do have a strong purpose to have this subcommittee hearing. I now recognize the ranking member, the gentleman from North Carolina, for 1 minute.
Look, insider trading is wrong. We can all agree on that. The SEC, I think we can all agree, is doing a really good job to pursue bad actors. What we should be spending our time on, as my friend Bill Huizenga just said, we should be spending time on identifying solutions that strengthen our economy, strengthen our economic recovery, and help our workers come back safely to the workforce after the virus, after we get testing and treatment going. And today I introduce a bill to do just that, the Gig Worker Equity Compensation Act. Today, an increasing share of our workforce does not want to be bound by traditional constraints such as an office or set hours or traditional employer-employee relationships. These gig workers are critical in our technologically driven world. My bill allows gig workers such as ride-share drivers or food delivery couriers to share in the same economic benefits, the upside potential of owning the businesses they're helping to improve. So today's hearing should be focused on that type of solution, not just a rear-facing set of issues in an election year. Thanks so much.
I'll point out that spring loading is legal until this committee makes it illegal, and it's just as wrong as the other.
In regular order, Mr. Chairman, if we wish to debate, the chair can debate, but you should not opine about everyone else's opinion. That is not in good form for the chair.
You were not recognized, but you did make your points clear. But when people question whether this is a legitimate hearing, it is appropriate to spend 10 or 20 seconds responding. Today, we welcome the testimony of Rick Claypool, Dr. Jill Fisch, Mr. Jacob Frenkel, and Mr. Gavin Martin. Mr. Claypool is a research director for Public Citizens President's Office, where he focuses on corporate crime and wrongdoing and the ways in which corporate power distorts our democracy. Dr. Fisch is the Saul A. Fox Distinguished Professor of Business Law and co-director of the Institute of Law and Economics at the University of Pennsylvania Law School. Mr. Frenkel is chair of the Government Investigations and Securities Enforcement practice at Dickinson Wright. He also previously served as senior counsel for the SEC's Division of Enforcement. And Mr. Martin is senior vice president and general counsel for the Society for Corporate Governance, where he leads the society's efforts related to corporate governance, securities laws, and regulations. Witnesses are reminded that your oral testimony will be limited to 5 minutes. A chime will go off at the end of your time, and I will ask you to respect our rules here by wrapping up your oral testimony. Without objection, your written statements will be made a part of the record. So we will now recognize our first witness, Mr. Claypool.
Thank you. Chair Sherman, Ranking Member Huizenga, members. On behalf of more than 500,000 members and supporters of Public Citizen, many of whom are investors and who, like all Americans, are hopeful for the timely development of safe and affordable COVID-19 treatments, we welcome this probe into insider trading during the pandemic. The reported events are concerning. Chair Sherman described the Kodak concerns well. Additionally, Moderna Therapeutics announced that all 45 participants in the first phase of its COVID-19 trial who received its vaccine developed some antibodies. This is good news. It's good news that pushed up the company's stock price 30% to an all-time high of $87. Prior to the announcement, several executives modified existing or adopted new 10b5-1 plans. In the days following the announcement, Moderna's CEO, other executives, and funds controlled by the board sold about $90 million worth of company shares. Now, remember that it's taxpayer money funding 100% of this work to develop a COVID-19 vaccine, all of it. Now, a study published by a coalition that Public Citizen helps lead found that stock market value for the 8 biotech companies on the S&P 500 grew by $130 billion between January and August. And executives and insiders from just 3 of these companies, Moderna, Inovio, and Vaxart, sold at least $370 million in company stocks, inflated by news of government awards and trial results. Now, meanwhile, NPR is reporting that the number of SEC insider trading enforcement actions has plummeted to its lowest point in decades. Public Citizen research has documented declines in corporate and white-collar crime enforcement at the SEC and across the federal government. If the agency is following the Trump administration's orders to stand down, as numerous government-wide policies, such as a May executive order and subsequent August OIRA memo, direct, then that alone deserves a hearing. As for legislation, we look forward to full House passage of Representative Cynthia Axne's bill requiring the SEC and CFPB to provide monthly reports on consumer and investor protection activities. Ideally, the SEC will want to report a significant enforcement increase against opportunistic insiders. We applaud the House for approving the Public Citizen-endorsed insider trading reform bill authored by Representative Jim Hines. Establishing a clear law against illegal trading will serve prosecutors well. We also applaud passage of the 8K trading gap bill authored by Representative Carolyn Maloney and the 10.5b1 trading plan authored by Chair Waters. One particularly promising deterrent is compensation deferral mechanism that requires recipients of CARES Act aid to place a significant percent of senior compensation in a collective pool. Should a corporation later be found to misuse CARES Act aid or aid from a successor law or engage in any other misconduct that results in fines, then the pool of senior managers' deferred pay would be used to fund the fines. Such a concept already exists in separate bills sponsored by Representatives Tulsi Gabbard and Katie Porter. Now, it is crucial for Congress to condition the trillions in federal aid, purportedly with the intention of helping workers, so that it is not diverted into the pockets of pandemic profiteers. We applaud this committee's contributions to the HEROES Act and look forward to working with you as you fashion the next necessary round of recovery and stimulus legislation. I welcome your questions and may draw on public citizen issue experts with written responses where relevant.
The chair is amazed. This may be the first time in decades a witness has concluded in well less than 5 minutes. The witness did not choose to yield his remaining time to me, and accordingly, I will recognize Dr. Doctor, you may be on mute.
Do I have it now?
Yes.
Okay, thank you. Sorry. Chairman Sherman, Ranking Member Huizenga, and members of the subcommittee, it's an honor to participate in today's hearing. Thank you to Chairman Sherman for the kind introduction. Just a point of clarification. I'm just a lowly law professor. I'm not a doctor. So thank you for the promotion. But I want to take just a few minutes to put the reported events to which Chairman Sherman and Rick Claypool referred in a little bit of context. In the past 6 months, as we all know, the capital markets have experienced unprecedented levels of volatility and trading activity. I know SEC Chairman Jay Clayton has provided this subcommittee in earlier testimony with data on both the high levels of trades and the incredible price swings that we've seen, not just in pharmaceutical companies, but across a range of industries that have been affected by the pandemic. And these fluctuations obviously create the opportunity for manipulation, for misconduct, for self-dealing. They've also drawn considerable media attention. I've written about securities fraud, SEC enforcement, and insider trading, and I want to focus in my opening remarks on a review of the regulatory structure and the challenges that the market environment imposes on that regulatory structure. The activities that I understand the subcommittee to be interested in today involve 3 distinct sets of legal issues: disclosure integrity, the use of stock options, and insider trading. I'll address those issues in turn. I'll briefly conclude by addressing potential areas of regulatory reform. So the first issue is disclosure integrity. Some news stories that we've heard say that issuers have made distorted, inaccurate, or overly optimistic disclosures to drive up their stock prices. And this can be for various reasons, ranging from enabling insiders to sell and make a lot of money, increasing the value of stock options, or facilitating the issuer's access to the capital markets. Now, let me be clear. Existing securities regulation requires disclosures to be accurate. False and misleading statements, particularly those that are made with an effort to distort stock prices or create opportunities for personal gain, that constitutes securities fraud. An issuer or corporate official that makes false claims about a pharmaceutical product that's under development, or misstates the results of a clinical trial, can face both an SEC enforcement action and private civil litigation. And false statements that are made willfully can subject the issuer and individual corporate officials to criminal liability. This is not a gray area. The existing market environment, however, creates a challenging disclosure environment. The scope of the pandemic, the lockdown, the effect on the world's economy are unprecedented. Pandemic-related information has the potential to have an enormous impact on the economy and on stock prices. Everyone is watching to see what's happening with these companies. And the SEC itself has encouraged issuers to provide as much information as possible about pandemic-related risks on businesses. But at the same time, we don't actually know what the truth is. The scientific community, the public health community is still evaluating all of this. So it's hard for businesses to predict what's going to happen in the future, what's going to be the effect on their stock prices, and so forth. So simply put, issuers are in a challenging environment. They're pressured to disclose as much information as possible, but premature disclosure of uncertain information may, in hindsight, prove inaccurate. Right? At the same time, stock prices are reacting dramatically. Chairman Sherman identified the possibility that stock prices may be too high at the time that executives receive stock options. The concept that stock prices reflect fundamental value, or that the fundamental value of these companies is even knowable at any given point right now, is something that is very challenging from a market regulatory perspective. Now, let me say, my time is running short, and as a law professor, I'm always long-winded, so I will cut to the chase and talk further, perhaps in response to your questions about stock options and insider trading. But let me just say a couple of words about potential regulatory reforms. As I said, the law doesn't prohibit accurate statements, even if those statements are forward-looking, even if those statements are not based on hard science about what a vaccine or what a product is going to do. The law, however, doesn't permit executives from creating trading opportunities through their public statements. And here I think the potential Chairman Sherman, if I could just take a minute to wrap up.
30 seconds.
Here, I think the potential rethinking of 10b5-1 plans, which I think the current market environment has exposed, is creating a potential regulatory gap, a potential opportunity for profitable manipulation of disclosures in order for the potential of self-gain, is a really promising area. And I think it's an area that legislation and regulation haven't fully recognized. And I'd be happy to talk about that more in response to questions. Thank you.
Thank you for your testimony. You now recognize Mr. Frenkel.
Thank you. Good afternoon, Chairman Sherman, Ranking Member Huizenga, and distinguished members of this subcommittee. Thank you for giving me the opportunity to testify on critical issues impacting our capital markets. My perspective comes from 32 years of professional experience in capital markets enforcement, investigations, governance, and integrity issues, including my work at the Securities and Exchange Commission's Division of Enforcement, as a federal prosecutor of public corruption and securities violations, as an actively practicing defense and governance lawyer for more than 21 years. I believe that in 2020, unlike 20 or more years ago pre-Enron, most corporate boards and management want to get it right. Nevertheless, we still see capital markets activity that gives rise to questions about commitments to compliance and fundamental common law duties that are the responsibility of corporate custodians. This committee has identified insider trading, Rule 10b5-1 plans, and stock options grants, spring loading, and bullet dodging as issues of heightened interest and warranting consideration of legislation. Beyond these undeniable vital areas of concern, I suggest to the committee respectfully that COVID-19 solutions-related capital markets activities also should invite scrutiny of several other issues. They include, first, Regulation FD and its inapplicability to foreign private issuers. We saw the effect of the exemption 2 weeks ago when AstraZeneca's CEO disclosed on a non-public call arranged by JP Morgan about its suspension of vaccine clinical trials as a result of an unexplained illness in a trial participant. If AstraZeneca had been a U.S. issuer, then there likely would have been an obligation for prompt public disclosure of what appeared to be an unintentional selective disclosure. Second is the SEC's 10-day trading suspension authority, which operates like a court-imposed temporary restraining order. However, it is not an enforcement action, but operates as an administrative arrow through the heart of legitimate small entrepreneurial public companies. For trading suspensions that issuers contest, the SEC takes months, if not longer, to resolve the challenge. Legislation should dictate a precise and narrow time frame for making the decision. Third is delegation of authority to authorize formal orders of investigation at the SEC. For decades, the Commission alone made the decision. Post-Madoff, the authority was delegated into the Enforcement Division, what I and others viewed as an out-of-control practice in the previous SEC administration. Although SEC Chairman Clayton has reined in this delegation of authority, I believe that Congress intended for the commissioners to decide whom to investigate and to make the solemn decision about authorizing subpoena power, much like a federal judge reviews and approves search warrant applications. And fourth is trade clearance and conflict of interest disclosure policies and whether they should apply to NIH advisory panels. The question for consideration is what level of transparency should exist to enable you on Capitol Hill and the public to assess possible conflicts of interest among scientific and technical peer review advisors who are not subject to the Federal Advisory Committee Act. These are not instead of, but are in addition to the important issues already identified by this subcommittee. I hope that we will be able to discuss each of these issues this afternoon. Finally, you have asked that we address the importance of corporate integrity during the COVID-19 pandemic and the impact it has on investor protection and overall market integrity. I believe that is too narrow. Corporate integrity, a commitment to best practices and proper governance, including a conscientious discharge of common law fiduciary duties, and a constant focus on investor protection and market integrity, is during the pandemic, and always will be and must be guiding principles in corporate boardrooms and C-suites for U.S. capital markets participants. I compliment the committee for highlighting the importance of and addressing these issues with this hearing. I look forward to answering your questions this afternoon. Thank you.
Thank you. As described earlier, Mr. Meeks will be taking over while I need to vote. So I'm hoping to encourage Mr. Meeks to vote in the next few minutes, since I'll be turning the gavel over to him in about 20 minutes. Greg, does that work for you?
Very well. I'll run the vote now and I'll be back.
Good. See you in 15, 20 minutes. With that, recognize Mr. Martin. Mr. Martin?
I, of course, didn't unmute myself. You think I'd be used to this by now, 6 months into this. Apologies. I'm also wearing a tie for the first time in many months, so thanks for the opportunity to do that. Chairman, Ranking Member Huizenga, and members of the committee, thanks for the opportunity to testify today. I'm Granville Martin, General Counsel for the Society for Corporate Governance. The Society is a professional association of approximately 3,500 corporate and assistant secretaries, serving approximately 1,000 public companies. Our members support the work of corporate boards and executive managements on corporate governance and disclosure matters. We traditionally focused on securities and corporate law issues, and in the last several years have broadened our perspective to also include environmental and social issues. Diversity, climate change, human capital management are among the ESG issues which investors have sought greater disclosure on, and that public companies increasingly provide. At the outset, let me state clearly the Society and its public company members support a rigorous framework of insider trading regulation and enforcement, ensuring America's capital markets retain a reputation for transparency and fairness is in the interest of all public companies. A market where insiders can benefit from material non-public information at the expense of other investors is wrong, and we support the laws and enforcements necessary to prevent and punish such conduct. Most public companies have adopted policies to prevent illegal insider trading. Common features of such policies include a prohibition of trading at any time while in possession of MNPI, a pre-clearance procedure of transactions, imposition of trading blackout periods, and limitations on the adoption of 10b5-1 plans. It's worth noting that company-imposed blackout periods restricting executives from selling stock generally begin several weeks prior to the end of the fiscal quarter and last until a day or two after the publication of quarterly earnings. As a result, company officers and directors typically will have 4 open windows per year, with each window lasting just a few weeks. Section 10B of the Securities Exchange Act and the associated Rule 10b5-1 prohibit stock sales made on the basis of MNPI that is obtained through a breach of duty of trust that is owed to the issuer of that security. Rule 10b5-1 specifies that a sale of security is made on the basis of MNPI when the person making the sale was, quote, aware of that information when the sale was made. Rule 10b5-1 also provides an affirmative defense to Section 10b insider trading allegations when such trades are made pursuant to a pre-existing written trading plan that complies with the rule. The rule's affirmative defense is only available, however, if the plan was entered into in good faith. Rule 10b5-1 does not operate in a vacuum. It does not alter the elements of a case under Section 10b. Scienter is still required. Additionally, transactions pursuant to a 10b5-1 plan must still comply with the volume limitations of Rule 144, the short swing profit rule 16b. In addition, executives are subject to the filing of ownership forms under Section 16a of the Exchange Act, including Form 4, which must be filed in connection with each transaction. The filing of Schedules 13D and 13G are also required where appropriate. The Section 10b and Rule 10b5-1 prohibition on insider trading when aware of MNPI, along with the related disclosure obligations and established company practices, provide, in our view, a comprehensive and effective legal framework. We do not believe that changes are warranted. Like so many other aspects of our lives, COVID-19 presented new and abrupt challenges to public companies, including related to insider trading law compliance. As companies grapple with the implications of the pandemic, the SEC issued guidance emphasizing market integrity and urging companies to provide detailed COVID-related disclosure. Based on our review of society members' disclosures, we believe public companies have responded robustly to this guidance. COVID-related disclosure has been widespread and has covered a wide range of topics. In addition, many public companies reassessed their insider trading policy compliance programs, including whether their internal procedures were able to identify all of the executives who were now possibly in possession of COVID-related MNPI. Pre-pandemic, such concerns for supply chain and operational executives were minimal. Let me turn to some of the pending legislation. In general, the society does not have a position on the appropriateness of the amount or structure of executive compensation. Having said that, we would observe that the use of stock options by startups and other early stage companies is common and essential. Boards of directors and their compensation committees are best positioned to decide on the appropriateness of such options grants. Investors express their view of the appropriateness of compensation through required say-on-pay votes that occur in many cases annually. Transparent fairness exists under the current regulatory framework. Similarly, we believe the 8K trading gap bill is unnecessary, given that Section 10B and Rule 10b-5 already prohibit trading by insiders if the undisclosed significant event is material. We would note that the bill makes conduct that is already prohibited further illegal. That's possible. We believe the regulation of insider trading, almost done. We believe the regulation of insider trading has been subject to some confusion. Having said that, the SEC study mandated by HR 624 could contribute to a common and well-founded understanding of 10b5-1 plans and whether any changes are warranted, and we support the enactment of HR 624. Thanks for the invitation to testify, and I'd be happy to answer any questions.
Thank you. I now recognize myself for 5 minutes. I want to commend the chair and the ranking member for authoring legislation that has already passed the House dealing with instructing the SEC to focus on insider trading and certain aspects thereof. And one of the purposes of this hearing is to join forces with the ranking member and the chair to make that statement very clear to the SEC. It is the hope that these hearings will inspire the Senate to act on that bipartisan legislation, or just as good, get the SEC to do what the legislation directs them to do, whether statute directs them to do it or not. Insiders hold material information that is not known to the general public. We have insider trading rules that deal chiefly with transactions between the insider and outsiders through the market. We have much weaker rules or no rules dealing with insider trading in options or stock between the insider and the corporation itself. Now, I know that the minority can be very popular in the boardrooms of this country by saying that it's illegitimate to have a hearing of this subcommittee, except if the purpose of that hearing is to make it easier to market stock to the public. And there is a role for us making it easier on business insiders to raise capital. But it is certainly legitimate for this subcommittee to explore the loopholes that cause insiders to be able to take advantage of the general public and the general investing public. We do have good laws on traditional false statements. The SEC has done many thousands of enforcement transactions dealing with traditional insider trading. But when insiders make use of material undisclosed information in stock option transactions and other transactions with the company, according to Kodak's lawyers, and frankly, including and even in our discussions with the SEC, can generally be legal, though wrongful. Ms. Fisch, as you know, the day before the federal government announced its plans to provide Kodak a $765 million loan, the company's CEO was granted 1.75 million stock options. Now, stock option plans legally need to be approved by shareholders, and the shareholders approved a plan that said that the option exercise price for these employee stock options needs to be set at, quote, fair market value. But here's where the shareholders may have gotten tricked, because that's defined as the latest closing price of the shares. And under normal circumstances, that is fair market value. But in this case, Kodak, undisclosed to the market, had just landed $765 million. considering Kodak's share price rose by over 500% within hours after these options were granted. This seems to be a situation where the shareholders were fooled by fair market value, which turned out to be a much lower a value that didn't reflect the knowledge. Would you agree that legislation is appropriate to close this loophole by prohibiting users who use fair market value to set employee stock option exercise prices from doing so based on a market price that doesn't reflect information the company is about to disclose and is required to disclose?
Thank you, Chairman Sherman. So stock options obviously are a form of executive compensation. And as compensation, they've got a number of problems. One of the problems that we see right now is there's a huge amount of volatility in prices. Prices are reacting, as you yourself observed, prices may be overreacting to information as well. So I think a compensation structure that looks at market price as an indication of fair value is particularly problematic in this environment. That being said, the whole regulatory structure is designed to put safeguards into place, not just the shareholder vote, but also the role of the compensation committee.
Thank you. My time has expired. I now recognize the ranking member of the subcommittee, Mr. Bill Huizenga.
Thank you, Mr. Chairman. Appreciate the opportunity, and I would like unanimous consent to submit a letter for the record that is from the Securities and Exchange Commission, Chairman Clayton. It's addressed to you and CC'd by me. I'd like to put that into the record.
Without objection, so ordered for the second time, since I had already put it in the record. Now it's there twice. That's good.
Double, belt and suspenders. So, all right. Appreciate it. And maybe I'll just start with where Professor Fisch had left off. And in this letter, the chairman is very clear about some of his concerns about the 10b5-1 plans. In fact, he's sort of a couple of the headings on this are insider trading policies for senior executives and board members, terms and administration of rules, 10b5-1 plans. He does say also in the letter that there is a joint explanatory statement accompanying the fiscal year 2020 FSGG Appropriations Act on the growth share repurchases, and are considering this and other issues relating to Rule 10b5-1 as plans as part of that report. Issuing and pricing stock options, he very specifically says that a grant may also be inconsistent with existing accounting standards because, in short, the trading price of its stock is not a good indicator of fair market value. And he then goes on to ask to make sure that senior executives and board members keeping that in mind, but also to have the Division of Corporate Finance and enforcement to look at that. So, Professor Fisch, I don't know if you care to address that very briefly any more than what you had started to go down that path.
Thank you. I guess what I did want to say is you're absolutely right, and of course, SEC Chairman Clayton is absolutely right. Good corporate hygiene, I think, these days requires a corporation to think seriously about having written, explicit policies in place with respect to its option grants, with respect to its executive trading in the company's stock, and with respect to 10b5-1 plans. I think those are all important issues. But I just want to distinguish between good corporate hygiene, matters of good corporate governance, even matters of a director's fiduciary duties, and insider trading, because they're two different concepts. And lots of companies can be overpaying their executives right now based on salary or bonuses that are tied to stock prices without using stock options, right? So the problem is the overpayment. The problem is using stock prices as a metric of value. And the problem is not necessarily in the option form itself.
And the chairman says that that may be inconsistent with existing accounting standards. So is that something like the PCAOB needs to tackle?
So that's an interesting question. And the problem is, I'm not sure how you come up in this market environment with a concept of fair value and how a board or a compensation committee goes ahead and does that. Now, Chairman Sherman is right. If the company knows tomorrow it's going to release material information, the company is obviously going to suspect the stock price is going to be affected. But if you look at Kodak's trading price from the time before the first press reports until today, it's all over the place. And I don't know at which point the trading price, we could say with confidence, yes, that reflects fair market value.
I think that point has been made. It's more than just one company, but the SEC clearly is very concerned about it. The chairman is. Quite honestly, when Mr. Claypool was, I would say, disparaging the chair, whether it was Mary Jo White or Jay Clayton, I don't think I have ever heard a SEC chair even come close to thinking that insider trading or that enforcement is somehow not acceptable. So that just was wrong-headed on that. Mr. Martin, you specifically, companies participating in government assistance programs through the CARES Act have some guidance that has been put up, correct? And through that, do you believe it's clear enough?
Yes, I do. I think the company response to the SEC guidance, both the statements with respect to insider trading and subsequent statements by the chairman and director Bill Hinman, were well received. It was very clear to the corporate community, and what you saw was a big increase and needed increase in COVID-related disclosure, which the chairman was very focused on, along with the director. We can provide a few statistics about the increase of that disclosure. And appropriately, and I think Professor Fisch was alluding to this, companies were really struggling at the beginning, and to some degree still are, with understanding what the significance of particular events are to their own business operations and indeed their stock price, and have been extremely volatile, and so companies have struggled with that, and their response significantly has been to very dramatically increase the amount of disclosure on COVID. For example, just at the end of March, an NACD study found that 50% of the Russell 3000 companies that filed a Form 10K as of March 30th.
I believe the
coronavirus or COVID-19.
The time of the gentleman has expired.
Excuse me, I'm sorry. One last point.
Mr. Himes, it's your turn. Have you already voted?
No, I have not, but I think I've got time, so I will use my time now.
I will not only Ms. Porter, have you already voted, or are you voting by proxy? Please unmute, Ms. Porter.
I have already voted, sir.
Good. I'm going to, since Mr. Meeks has not returned, and with your permission, I'll make you temporary chair as I go vote.
And Mr. Chairman, I guess I'm looking to see if there's a Republican that is on as well to take the helm. While this is one of the challenges of having committee hearings continue on while we're doing extended voting. But I'd love to hear one of my Republican colleagues let me know that I can.
Okay, I am going to call upon Ms. Porter to act as our temporary chair, and ask Mr. Meeks to proceed. Ask Mr. Himes to proceed for 5 minutes. Thank you.
Great. Thank you, Mr. Chairman. And thanks very much to our witnesses today. This is an area of intense interest for me. My office has devoted a lot of time to crafting what was, as the ranking member pointed out, bipartisan legislation which passed the House in late 2019 with HR 2534, the Insider Trading Prohibition Act. Very, very interested in that, very steeped in the complexity of defining insider trading. I do have a question, but since it was a bipartisan bill, I want to suggest to my Republican friends, this is far from a waste of time, and it may not be exactly the way you want to promote business investment. But there is arguably nothing quite so important to business investment as confidence in the capital markets, the confidence on the part of shareholders and others that they are playing in a fair market, which is why I have been very, very devoted to crafting a specific statute on the topic of insider trading. There is a need for this. My Republican friends know that only 14% of Americans directly own stocks. And so as the stock market has rocketed in these last couple of years, directly, a very small percentage of Americans have been able to participate in that upside. It is true that roughly half of Americans, of course, indirectly own some stock through pension plans and retirement plans, but we should all be looking to increase the number of Americans who feel like they've got a stake in the equity of their economy. And critical to that, of course, is making sure that we can look people in the eye and say, this is a fair and level playing field. I don't want to get into the complexities of all that occurred in Kodak, and I understand they are complicated. Look, there's nothing wrong with stock prices going up necessarily. There's nothing wrong with stock option plans necessarily. What is wrong is when corporate insiders take advantage of inside information. So my question is, we spend a lot of time in the bill defining transactions, purchase and sales of securities. The fact that we're talking about spring loading and bullet dodging, that pertains to essentially a transaction, but it's an indirect transaction. It is the conveyance of value because a stock option is valuable. And so my question is, I'm not quite sure which of my witnesses, maybe I'll start with Mr. Frenkel. My question is, do you think we can alter insider trading law, broaden it to be about the conveyance of value, and would that capture what we're talking about here, or do we need an entirely separate statute for value that is conveyed via option plans and programs as opposed to the purchase or sale of securities?
Mr. Wright, I believe you're on mute.
I'm sorry. Thank you, Congressman Himes. And I apologize for being on mute. I think in the context of the insider trading laws, where the focus has always historically been on the purchase and sale and the conveyance of information. To me, as Professor Fisch had indicated, the issues around spring loading and bullet dodging are as much a part of executive compensation as they are the information. Insiders are always going to have access to information that is imbalanced with respect to the rest of the market. I believe that really is more an issue of timing and broader disclosure obligations than insider trading itself.
No, I understand that. And I guess the point I'm making, and I understand that we're really talking more about compensation than a purchase or a sale of a security. But at the end of the day, what is happening is that a decision about the conveyance of value is being made possibly when there is an imbalance of information. So it's not clear to me that there's a radical categorical difference between an executive who is going to approve a stock option plan 3 weeks from now, but knowing that they're about to receive a loan accelerates that decision. There's not a categorical difference between that and that executive going out and purchasing the stock. There are differences in timing, et cetera, but it's effectively the same thing. It is conveying value wrongly because inside information is had, right?
I would agree. Congressman Hobbs, you're correctly identifying the issue as being the use and application of that information as being subject to an imbalance favoring that corporate executive. I still believe it is an issue that really should fall beyond insider trading because it really does not relate to a trade itself. It really goes to disclosure issues, in my view.
Yeah, my time has expired, but I think I would be grateful if in this hearing we got down to how can we address legislatively spring loading and bullet dodging most appropriately. But my time has expired, so I'll yield back and thank the witnesses.
The chair now recognizes Mr. Gonzalez, the gentleman from Ohio.
Thank you, Madam Chair. Thank you, everybody, for your testimony today. I want to start with something that Mr. Claypool brought up that just kind of perked my interest, and I'm curious for everybody's take on it. You highlighted the Moderna situation where, upon getting good news, stock price went up significantly, sold stock. Nothing in and of itself wrong with that, but it does sort of raise a question around COVID support and specific COVID support. To me, it does anyway. Specific COVID support and any additional disclosures we might want as a result of that. I think these are unusual times, and when we have federal government basically funding 100% of R&D on a product that is going to be incredibly important, God willing, maybe there should be additional scrutiny there. I guess I'd start first with Mr. Martin. Do you have any thoughts on how we could better inform investors with respect to these sorts of announcements, or any changes you might make on a temporary basis, not permanent, but on a temporary basis as a result of COVID?
Well, I think the existing framework that necessitates the disclosure of material information to investors through the filing of an 8K is the appropriate mechanism. To the extent that there is trading around or in advance of such disclosure, that's already illegal. So it's not immediately evident to me what an alternative framework can do beyond what the existing framework does, which is to mandate the disclosure of material information to investors. And so I'm sorry, but I don't have any particularly intelligent ideas as an alternative to that.
No, that's a fine answer. I just wanted your perspective on it. And now another thing from Mr. Claypool's testimony, this one I would take issue with, which was around sort of a normative judgment around repurchasing of stocks in particular. There's just a quote in here: when managers repurchase stock, they are confessing they have no new promising ideas in which to invest. Mr. Martin, again, what do you think of that statement? I mean, I'll just say, I don't want to set you up to be overly combative, but as somebody who's been an investor for my entire adult life, when companies I've invested in repurchase stock, that means that I own more of the company now. And so that actually benefits all shareholders, is my personal belief. But I'd be curious for your perspective on that as well.
Well, I agree with that. Share repurchases are a legitimate tool for capital planning for companies. Of course, companies can raise or lower their dividend as needed, and share repurchases are an entirely legitimate use of shareholder funds in order to, for the benefit of existing shareholders. So, I know that there are strong feelings about that, particularly in the wake of some tax legislation a few years ago. I just disagree with that perspective, and would hope that Congress will maintain the discretion that companies have to make those kinds of capital planning decisions, and the boards and senior management are left to make those kinds of determinations.
Thank you. I agree with everything you just said, and I yield back.
Thank you. I'm now going to turn over the chairing of this hearing to my colleague, the distinguished gentleman from New York, Mr. Meeks. You just need to unmute yourself, Mr. Meeks, and you'll be all set.
Thank you, Congresswoman Porter. Thank you for holding it down for us. I now will yield 5 minutes to the gentleman from Illinois, Mr. Foster, for questions.
Thank you. All right, am I audible and visible?
You are.
All right. Professor Fisch, I'd like to take you up on your offer to dig a little bit deeper on 10b5-1 plans. Some of the stories that we've seen regarding pharma companies developing COVID-related products apparently involved executives modifying these plans right before some big announcement, which caused the stock to skyrocket. Some of these apparently have resulted in what might otherwise be considered suspiciously timed trades, but are given at least a partial safe harbor because they were done pursuant to 10b5-1 plans. So very quickly, could you sort of briefly describe what 10b5-1 plans are and what they're intended to be and accomplish?
Thank you. So yes, 10b5-1 plans are designed primarily as a tool for executives to manage their stock trading over the long term. So today, executives increasingly are being paid in stock, stock options, restricted stock. Obviously, they have liquidity needs. And the idea behind a 10b5-1 plan is typically what this allows you to do is sell stock on a regular basis, right? They're usually used on the sales side, and not worry about the fact that before you sell the stock, you come into possession of material, non-public information, and you thereby be precluded from selling. Once you put the plan in place, once you commit to sell, you're insulated from liability, even if you have knowledge at the time the sale actually occurs. Now, the loophole, Congressman, that you're referring to is the fact that these plans, number one, the plans don't have to be disclosed. And practice among issuers varies dramatically in the type of disclosure that they make or whether they disclose the existence of these plans at all. So that's the first problem. The second problem is the law allows you to modify or to terminate your 10b5-1 plan, and it doesn't restrict that termination to situations in which you don't have material non-public information. So let's say I have a 10b5-1 plan. I'm planning to sell my stock this week. I learn good news about my company, or it's going to get a federal grant or promising drug trials. And I just say, okay, hang on, I'm going to terminate my plan. I'm not going to sell. Obviously, I'm making use of inside information, but I'm not trading. I'm declining to trade. And as a result, it's a loophole that's not covered by existing law.
Is there a downside in mandatory disclosure of these, either in real time or at quarterly intervals or some standardized time?
Frankly, sir, I don't see a downside. And in fact, there have been a couple of empirical studies that have looked at issuer disclosure practices and found that the issuers who disclose these plans voluntarily also have better general corporate governance. In other words, disclosure seems to be a signal of good corporate hygiene, so to speak.
And what about requirements that separate the decision time from the time of the actual purchases? So that you have to declare months or longer in advance that you are going to start or stop this program?
So that would absolutely be a useful refinement as well. So we haven't yet talked in this hearing about 16B and short swing trading liability. That's a provision in the original Securities Exchange Act of 1934 that's supposed to limit the ability of executives to benefit from sort of short-term trading by buying and selling within a short time period. I think you could apply that same approach to 10b5-1 plans and say, look, given the intent behind these plans, you should have to put the plan into place for a period of time. And ideally, the plan should persist for a period of time so that there's less likelihood that executives will try to take advantage of short-term information asymmetries.
And do any of the other witnesses have any comments on this area of potential improvements or fixing loopholes or other risks? All right, deafening silence. Well, I appreciate all your help. I appreciate, as the son of a law professor, I just have a lot of sympathy for your life. And anyway, we'll have that discussion offline. And with that, I yield back.
Thank you very much. Thank the gentleman for his questions and commend to him and others the Waters McHenry bill designed to focus on the problem he illustrates. I want to thank Ms. Porter and Mr. Meeks for acting as temporary chair in my absence and recognize Mr. Hill.
Thank you, Mr. Chairman, and what a good discussion this is. And I want to, of course, commend and thank all the members who've worked on insider trading topics over the years, but particularly my friend, Mr. Hines of Connecticut, who's been such a thought leader on this subject as our committee has navigated what is a very challenging subject in order to balance the needs for the information in the capital markets, the flexibility of use, and really identify criminal behavior. So thanks, Jim Himes, for your work and for the bipartisan work that we've done together. Mr. Martin, I want to talk a little bit about the Society's survey on the members regarding insider trading pre-clearance policies. You say 90% of your members follow a pre-clearance policy. And could you highlight what your best practices would indicate that could have prevented or brought clarity to or remediated some of the challenges that we've read about in recent days and that we've talked about over the course of this hearing?
Sure. So in general, I think there's a suite of policies that corporates implement to, as was said at the outset, that 20 years ago, I think it was Mr. Frenkel who noted that the change in most corporate suites to take insider trading and avoiding it and regulating it is companies are taking it very seriously. So there's a suite of policies that they've instituted to address that. Compliance training with executives that requires the executives to acknowledge the existence of the policies, that they understand what the limitations are, including obviously you can't trade while in possession of MNPI. The designation of particular brokerage houses to handle all transactions in company stock that allow Section 16 executives and others who may have MNPI to be flagged. And so those accounts can be monitored. You mentioned the survey that the Society conducted about 2 years ago that indicated approximately 90% of the companies surveyed require pre-clearance of trades by in-house legal. I mentioned in my opening remarks, virtually every company imposes blackout periods in advance of quarterly earnings, but it's more stringent than just that. Those windows will be closed in the event that new material information develops. Could be a leadership change, could be something with respect to a new product. And then, of course, some companies further regulate the adoption of 10b5-1 plans when they can be adopted and cooling off periods and things like that. So there's a suite of policies that companies have become much more conversant and frequent users of because trying to avoid their executives becoming embroiled in an insider trading allegation or enforcement action is incredibly time-consuming and expensive for companies. And the incentives are really lined up for companies to try to avoid those kinds of outcomes.
Yeah, my limited experience in this area is also in a very active company that's growing and doing mergers and acquisitions and having executive management changes and maybe having a very periodic 8K filing process, is that the number of days somebody can actually trade their stock is very limited per quarter. I mean, just fractionally. Is there a better way, now that we've seen the expansion of stock options over the past 30 years, is there a better way to provide long-term growth-based compensation to executives other than stock options? Have you all done any studies on that?
I don't think we've done particular studies on them. You know, obviously the question of how long vesting periods are is pertinent to your question, and I can speak from my own personal experience, and I know I'm out of time, is that those vesting periods for some executives have been pushed out.
Thank you. I look forward to following up with you on that, and I appreciate, Mr. Chairman, my best regards to our panel. It was an excellent discussion.
Thank you. And now recognize my fellow Californian, Mr. Vargas.
Thank you very much, Mr. Chairman, and I appreciate very much the words of my good friend, Frenkel. I was a little surprised when this hearing started, when I heard the ranking member and others say basically, there's nothing here to see. Why don't we just move along? And there seems like there's a lot here to see, at least from my perspective. I mean, you know, I appreciate the effort that the pharmaceutical companies are putting forward to develop a COVID-19 vaccine and the treatment supplies. And of course, they should be compensated. I believe that they should be, but I'm also concerned about the large amounts of money that they're making when the rest of the country is having such a difficult time. And I guess I'm very concerned about the legal but wrongful aspects of this. I mean, it really does seem to me that if what Kodak did was legal, it's certainly wrongful. And I do not have great confidence in the SEC at the moment. Their enforcement's way down. So I think that we have something here. Professor Fisch, could you comment on that? Is there nothing to see here? Should we move along?
No, I don't. I commend the subcommittee for raising what I think are very important topics, and I wouldn't say that you all should just move along. But what I think a number of the comments have suggested, though, is that you're actually focusing on two related but separate ideas. One is the conveyance or the wrongful conveyance or the wrongful misuse of information. And the other is the sort of the compensation and whether companies that are facing speculation in their stock price and also companies that are the subject of government funding, whether they should be compensating their executives to the degree that they are. So, you know, stock options and some of the recent stock option experiences involve a combination of the two. And I think members of the subcommittee, at least some members, might be equally upset if these executives were getting huge grants just in the form of salary. Now, obviously, there's nothing wrong with a compensation committee deciding to pay an executive millions of dollars before the news of a government grant has been publicly released, right? The compensation committee knows about the government grant. It's not a misuse of non-public information. But, you know, you might think, well, gee, it smells bad. This is taxpayer funding. This isn't something the executives should profit with, right? That's a little bit different from the stock trading or the insider trading concept.
Well, Professor, I think it does smell pretty bad, to be frank. Frenkel, if you could speak a little bit about spring loading and bullet dodging you were talking about earlier.
I would agree with all the comments that have been made so far with respect to spring loading and bullet dodging. I think the focus has been more on the spring loading component, where the bullet dodging piece of it is about a company temporarily depressing the stock price by releasing information before a stock option grant date, as opposed to the holding back the release of the positive information until after the option date. I think one of the courts in Delaware, if I'm not mistaken, a number of years ago, referred to spring loading and really in particular spring loading as being a matter of a corporate disclosure conduct issue involving an unclean heart, but not necessarily a violation of law. And I think what we're really talking about here is moving the whole discussion into how to provide some form of disclosure and regulation around these concerns. The one thing respectfully that I think I should also address is the issue of SEC enforcement in this area. Because while the SEC's numbers may be down, I would submit as somebody who defends these investigations, the commission is very aggressive. There have been 40 trading suspensions that are specifically related to issuers in the COVID-19 solutions space. So the commission really has been very vigilant. On the other hand, as it has been dealing with staff reductions, that also has impacted its ability to be as broad in its application or choice of cases. But I think in terms of the gestation of investigations, I think we're still seeing a very active division, just sort of a reprioritization over the last 18 months.
My time is about up, and not to be confrontational or be difficult, but I would disagree with that, especially when you see what happened with Kodak. I mean, I don't know how you explain that to the American public. Thank you. My time has expired.
Now recognize the recent former chair of this subcommittee, the gentlelady from New York, Ms. Malone.
I thank the gentleman for yielding, and thank you for this important hearing. Mr. Frenkel, I'd like to address my question to you. Earlier this year, the House passed my legislation, the 8K Trading Gap Act, with overwhelming bipartisan support. The bill would close the loophole in our current law that allows corporate executives to trade on information before it is disclosed to the public. And right now, when there is a significant corporate event at a public company, the company has to disclose that significant event to the public by filing a Form 8K within 4 days of the event occurring. Of course, during this 4-day gap, executives at the company know about the event, but their investors don't. My bill would address this problem by simply prohibiting executives from trading during this 4-day gap. Given the recent controversial activities that my colleague, Congressman Vargas, just mentioned at the companies like Kodak, Novak, and Moderna, I believe it's important now more than ever to close this loophole. Since the start of the pandemic in mid-March, there have been over 10,000 8K filings with the SEC. Mr. Frenkel, would you agree that during this crisis, when firms have increasingly made important public announcements, it's especially important that we close this loophole?
I would agree. I would agree entirely, and I think your legislation is right on point, and I think it also goes to a point that Mr. Martin had made before regarding corporate blackout periods. And certainly there is abuse, but I mean, using the example that Mr. Vargas had raised with respect to Kodak, I also refer to the committee statement from yesterday. The fact is, the SEC has not yet, let alone conducted its investigation, and the SEC certainly can come to entirely different conclusions than the findings of the internal investigation. Because if you look at the report of the internal investigation, I believe the questions that were posed were extremely narrow. So, or at least that were addressed in the course of the internal investigation. So yes, back to the guts of your question, I do think that your proposed legislation around 8K disclosures is right on point and essentially legislates the blackout period, which is something that really does impose that level of control that that the market really warrants.
Also, as chair of the Committee on Oversight and Reform, I launched an investigation with Chairwoman Waters, Angle, and Clyburn into the administration's $765 million loan to Kodak. As part of our investigation, the Oversight Committee continues to investigate the reasoning behind the U.S. Internal Development Finance Corporation decision to provide the loan and whether they violated their own policies and procedures, and whether Kodak shared any material non-public information before the announcement was made public. Now, this was the International Development Finance Corporation. They gave it to a domestic corporation. That's a violation there, and to a company that had no experience, zero, in vaccines. Kodak itself has acknowledged that it is under investigation by the SEC, and this follows the unusual spike in the trading of its stock just one day prior to the July 28th announcement. On July 27th, more than 1.6 million shares of Kodak were traded, more than 6 times the average daily volume of shares a day during the previous 30 days. And while the increase in trading activity is reportedly a result of Kodak inadvertently releasing the news of the loan to local news outlets. Now, why did they do that? Where it is headquartered, Kodak waited until the following day to publicly disclose the announcement. Unless its stock holders were paying attention to social media, Kodak effectively kept millions of shareholders in the dark from the spike in trading activity. So, Dr. Frenkel, do you see this as a potential violation of Regulation FD, which states that when there's a, quote, non-intentional disclosure, the issuer must publicly disclose the information promptly? And if not, can this sort of trading activity still be harmful to shareholders and the market?
The answer, Congresswoman, is yes. There is the potential for a violation of Regulation FD, which I believe the SEC would include within the scope of its investigation. I would also point that as we look at the price of the stock, I'll be very brief on this, is that we're also dealing with issues such as potential stock manipulation, but also tipping, were there other people who traded, and were there people who potentially were involved on the put option side. I believe all of these things are something that the SEC will look at during the scope of its investigation.
When do you expect your investigation to be completed?
I believe the gentlelady's time has expired. If there could be a one-sentence answer, we'll hear it and then we'll go on to this.
I think SEC investigations in allegations such as this easily could run 9 months to 12 to 15 months.
Thank you, Mr. Meeks.
You're back. Thank you, Mr. Chairman. Thank you.
From gentleman from New York.
Thank you, Mr. Chairman. Thank you for doing and holding this important hearing. And I've been listening off and on to some of the witnesses and some of my colleagues questioning. And I think that what we have here is in the middle of this pandemic, which has killed hundreds of thousands of Americans. And I know that it has devastated the economy and a number of other things. The question that presents itself to us, though, is credibility. When we have a time of everybody questioning things, especially when you have the President of the United States questioning the scientists and doctors and when we're going to have a vaccine and when we're not, whether or not everything's on the up and up. So it also lies as we deal with these pharmaceutical companies and the search of trying to get a vaccine. And I agree that we need one sooner rather than later. And I agree that, individuals should be compensated for the appropriate amount of work that they do. But as we know, that there's no magic bullet. But a vaccine is a effective and safe thing that we need, as well as wearing our masks on a continuous basis, as the doctor said a testimony yesterday. And so I applaud all of the doctors, scientists, and companies working on this crucial project. So what it is the importance of the vaccine is why it is so unfortunate that we have, as I indicated, the president who just yesterday contradicted his own CDC director about when a vaccine will be ready. So I think we need to be building up the confidence of the American people. So that brings me to where we are now, because there's also a role, I think, for the capital markets and corporate governance to step up, because they understand the credibility issue and an important role to play here also. So I believe that we need leaders of these companies to have their incentives structured towards producing safe and efficacious vaccine. But we also need laws that can foster such productive arrangements while protecting the integrity of our capital market. So I'll start with Dr. Fisch. What are some of your ways you think that we can use corporate governance and combine with financial regulation to promote and encourage the development of safe and effective vaccines, while also protecting against some of the market misbehavior that I hear a lot of my colleagues talking about?
Congressman, I wish I had an answer for that question. I think, the challenge that we all face is, yes, in this environment, we really want to preserve capital market incentives. We want to preserve compensation incentives. If some company or some executive comes up with a vaccine, the whole world's going to say, yes, this is worth an awful lot of money to us. But corporate governance only gets you so far. Right now, I think sort of the gap between corporate governance and science is really wide. And that's part of the struggle, right? A company is taking baby steps. And I hear the debate about, well, companies should be precluded from awarding stock options until they file an 8K. a company may not know this baby step, this step with respect to testing progress. Is it going to pan out? Am I going to mislead investors if I say we're making progress? Am I going to mislead investors if I don't talk about the progress? So that's why I talked about this disclosure environment being very challenging to manage. And I do think it comes down to good corporate governance practices, but a lot of those governance practices are internal, right? How much is the board riding herd on all of this? How much is the board paying attention both to what the company's saying and to what its executives are doing? And so to a certain degree, right, that's not about insider trading and the securities laws. It's not about fraud, but it's about best practices.
Thank you. Let me.
Can I just add something there? I'm sorry, Congressman.
Go ahead. I'm running out of time, but go ahead.
I would just add that a lot of our companies have been trying to figure out how to and have revised how they to use their procedures around their disclosure committees. They've added individuals to those disclosure committees to try to add the right kinds of perspectives to get at what Dr. Fisch is saying. How do you assess the materiality of particular developments that pre-pandemic would not have risen to that level?
Thank you. Let me ask another quick question. You know, what I'm noticing, I had another one, but I won't get to it, that there's been a growing trend for companies to go public, not by using the traditional IPO process, but rather through a reverse merger with a special purpose acquisition company known as a SPAC. And I have serious concerns about this new trend and wanted to know if you see any potential implications for insider trading law or other issues with SPACs. Just curious, if you could just say yes or no, you have some concerns.
This is Jacob Frenkel. I could certainly address that very briefly.
Please, the chairman will allow.
The issue, thank you. The issue, thank you, Mr. Chairman. The issue with reverse mergers is not just SPACs, it's also with reverse mergers with, with essentially dormant public companies. That's something that is a hot topic issue for the SEC, has been for probably 30 years, if not longer. It is not an insider trading issue. It really is one more of a market structure issue.
Thank you very much. The time of the gentleman has concluded. The next two questioners, I believe, are both voting, and at the suggestion of staff, we are going to take a 10-minute recess. We'll reconvene. Gottheimer is next to be recognized for 5 minutes.
Thank you, Chairman Sherman, and thank you to all of our panelists for being here today. When the pandemic first hit, my district in northern New Jersey was in the eye of the COVID storm. New Jersey had the second highest rate of cases in the country, and the supply of protective gear was uncertain. Some healthcare providers estimated that supplies would run out in a matter of days. To help remedy this, I called on the administration to use the Defense Protection Act, DPA, to leverage America's manufacturing capacity and to make sure the necessary equipment is ready to keep fighting the pandemic. Using the DPA is crucial in our fight against COVID. However, I was just as surprised as many of us when the International Development Finance Corporation, DFC, announced that they would issue their first DPA loan worth $765 million to Kodak to produce pharmaceutical components. The DPA is finally being utilized, but to a company that has only just recently left bankruptcy with no proven success record in pharmaceuticals, being entrusted with such an important task. Frankly, it's a joke. Still, we know who was not surprised. Kodak's CEO purchased 46,737 shares of the company leading up to the announcement and received a 1.75 million stock options from the Kodak board the day before the announcement was made. These stock options may have been worth as much as 50 million just a few days later. I helped lead a letter from this committee to the SEC urging an investigation surrounding these transactions and market movements, and I was pleased to hear that the SEC has opened an investigation, that the DFC's Inspector General is investigating the origin of the loan. Mr. Frenkel, knowing the circumstances around the loan, the purchasing of the stocks by corporate insiders, the options granted, the early leak of the announcement, would you say there is a potential here for unlawful insider trading?
I think I'd go beyond that. I think in terms of, we're talking potential violations. I think there is the potential that the SEC could find, a range of violations, including in the disclosure arena in terms of trading, in terms of possibly even, the individuals involved in, in manipulation. We don't know. And I think the fundamental issue from my perspective is we have to give deference to the SEC to allow it to conduct its investigation. I also think that we have to be mindful of one other thing, which is that when we talk about the specific securities laws violations, if we go back to insider trading enforcement in the 1970s, 1980s, 1990s, those cases primarily were brought out by the Southern District of New York, charging as wire fraud and mail fraud. So there is also a broad range of federal criminal statutes that potentially can apply, even if there may not be a specific SEC law or regulation that could fall within the scope of violation. So in terms of the potential scope of the investigation, I think it's real. I think that if you, as I mentioned earlier, if you look at the questions that were posed by the internal investigation by outside counsel, they're very narrowly framed. So I think to the committee's point, there still is plenty for the SEC to look at, and there is the potential for the commission, for the enforcement division to find and recommend enforcement action, but only time will tell.
Thank you, sir. Thank you. I appreciate that response. Would you discuss a little more kind of the harm this causes shareholders and potential harm here, shareholders and capital markets and the taxpayers?
If you're directing that to me,
Yes.
I mean, to me, the core issue one is credibility. Interestingly, I actually go back to the language of the 33 Act. When you look at the preamble of the 33 Act, it's right full and fair disclosure of the character of securities sold and interstate and foreign commerce through the mails, and to prevent frauds in the sale thereof. I think everything that this committee is doing on a bipartisan level is very much directed towards, and I support it fully, is directed towards enhancing disclosure to ensure that there is that level of the ability for the public, for participants to have confidence in our markets. And I think that continues to be really the core issue: credibility, transparency, and confidence.
Thank you. I mean, our country is clearly, on the cusp here of many questions that we need to get answers to. And where I live, we are home to so many life sciences companies that have decades of experience and success. Now is not the time, clearly, to place bets on during a public health crisis on unproven entities that are unprepared to help our nation through this pandemic. And I strongly agree that corporate insiders shouldn't profit from these misguided allocations of resources. So I look forward to our continued oversight. Thank you very much for being here, sir.
Thank you. I now recognize the gentleman who brings extensive security law experience to his service on this committee, Mr. Gatt. Mr. Caston, you're recognized for 5 minutes.
I apologize, Mr. Chairman. I didn't recognize that I had all that extensive securities law experience and didn't realize you were talking about myself. Thank you so much, Mr. Chairman, and thank you to our witnesses for being here. I want to start just by making 3 statements that I think are just factual and should be fairly non-objectionable. Capital markets are not moral. Capital markets are not immoral. Capital markets are amoral. They amorally, rationally allocate capital to places where we think there will be future cash flows. Number 2, statement of fact, rushing a vaccine to market too early is massively dangerous to public health. It's not tested on populations that are healthy prior to taking the vaccine. Not only risk their health from the vaccine, but risks future certainty about vaccine trustworthiness of all vaccines. And number 3, statement of fact, Operation Warp Speed has distributed, I think, about $9 billion to developers of vaccines. And the President of the United States is openly touting that there will be a vaccine available by Election Day. Those are facts. Given that amorality, question for you, Mr. Claypool, is it rational to assume that a company receiving cash from Operation Warp Speed, when the President of the United States is saying there will be a vaccine by the election, is it rational for a amorally rational investor to assume that that company might have an increase in near-term cash flows?
I think it's perfectly rational to think that, as a result of good news, that the company's value is going to go up. That said, there's not a place for, in the greater context of this crisis, and seeing the idea that, I guess one could also argue that it's rational for an insider to exploit insider information if they believe they can get away with it.
I'm not trying to ask you a gotcha question. I'm glad you agree with the first part. Is it not also rational to assume that if a company did see a surge in cash flows from that good news and a surge in their equity value, but that the vaccine was subsequently proven to be dangerous, that company might face longer-term liabilities, legal or otherwise, from bringing that market too soon? Okay, so is it then not rational for a informed, amoral insider looking at that information to say, it is in my amoral interest to participate in those markets, buy now and cash out quickly before that future liability comes home to roost?
I could see there is a logic to that sort of hedge. It strikes me as, I guess, more cynical than we would hope the companies that we're relying on to develop vaccines for all of us will be acting in this crisis. I think we expect good faith development for them to do the work that is their core business purpose.
Yeah, and I'm in no way, I don't mean my comments in any way to question the morality of the companies. I'm just making a comment about the nature of markets that are not immoral, but they're not moral either. They're just making judgments. And I have concerns about the public health risks of rushing a vaccine to market. When we have insiders trading on this information, and should the chickens come home to roost that we've rushed this out too soon, what concerns do you have about what that does to trust in our capital markets?
I think it's very dangerous. And I also would add that to the concern of spring loading and those kinds of issues, it's worth being concerned that good news could be withheld until after those stock options are issued in a way that executives are most able to exploit.
Well, thank you. I don't know what we do with this other than that back in the days when I was the CEO of a company, I had a professor in grad school who said the most dangerous type of leadership is leadership based on knowledge, because the preservation of power depends on limiting people around you's access to information. And I used to find when I raised money on Wall Street, as the chairman was praising me for, that Wall Street is a place where information is power. Sadly, it's also true of the current job I have. But I think we always need to keep our vigilance up in industries like that, where withholding information from other people is a way to gain power. Thank you, and I yield back.
I agree.
The gentlelady from New York, Ms. Ocasio-Cortez, is recognized for 5 minutes.
Thank you, Mr. Chair, and thank you for hosting this incredibly important hearing. I had a quick question. So much of what we are discussing today has to deal with prospects of insider trading and also tying CEO compensation to stock. And my question for Mr. Claypool is, when CEOs and corporate CEOs, pharmaceuticals and otherwise, are compensated with stock packages and packages where an enormous amount of money that they're being compensated in is in stock options, how does that potentially influence decision making for when it comes to the long-term health of a company or long-term decisions for pharmaceuticals?
Thank you, Congresswoman. That's a really interesting question because, so often the idea that, the premise of issuing stock options as a way of paying executives is intended to align the interests of a company with the interests of shareholders. And what we're seeing in, instances such as we're observing here is where this intense short-termism encourages ways for companies to look for ways to quickly raise the stock price or take advantage of volatile circumstances in pursuit of short-term gain. There have been a variety of reforms that have even companies have self-enacted. Most companies in the aftermath of the scandal where companies were backdating their pay to, it's kind of the opposite, where they knew that the price of the stock would go up, so they would sort of shift the date of the award backwards in time, was that many companies sort of picked, in fact, I think most companies now pick a sort of select date to award those stock options. That was a positive development. However, what studies are now showing is that companies are, trying to find ways to, say, time bad news, or at least beforehand, before the announcements, or saving the good news for after the set date. They know stock options are made. Now, every individual instance of this may have a very plausible explanation for why they announced the news they did when they did and the timing of the options. But the recent study has shown it's like over 1,200 companies that have this sort of V-shaped pattern in how they're paid, and the pattern is is greater for companies who pay above average amounts of stock options, and for companies that are hard to value because, like these pharmaceutical companies, whose their destinies are based on just the success or failure of often a single drug being developed, is a circumstance that invites shenanigans that I'm happy the committee is looking into, and hope we'll find ways to thwart.
Absolutely. Well, thank you, Mr. Claypool.
Congresswoman, could I just weigh in on that?
Yeah, absolutely.
Sorry to interrupt, but you identified concerns about short-termism and trading opportunities, but I think the academic literature reveals a bigger problem with option-based compensation, and that is that it makes operational decisions too risky. And I think that relates to Congressman Caston's concern about scientific development and, particularly vaccines, right? If you've got stock options, that's a real high-powered incentive to take risks so that your stock price balloons. And I think in this environment, right, that's an extra caution that we really have to worry about.
Absolutely. So, would you say it's fair to say that having these kinds of stock options could incentivize riskier behavior, and when it comes to an industry like pharmaceuticals, that could carry an elevated risk with it?
Absolutely. And I think where we see particular concern is in some of these companies that historically have not been profitable, where their stock price is very low to begin with, and therefore the potential downside is very limited, but the potential upside is enormous.
Thank you. Thank you very much. And I have one last question for Mr. Frenkel. You've been a prosecutor, and insider trading and perhaps activities that mirror or appear like insider trading are not exclusive to the private sector. We have seen some questionable activity right here in Congress. And I am really interested in your thoughts on the 2012 Stock Act, how it may fall short, and what are some of the concerns that you think there are with respect to Congress and members of Congress engaging in behavior that could be seen as or interpreted as insider trading?
I'll ask you to answer in just a couple seconds because the time of the gentlelady has expired.
Thank you, Mr. Chairman. I think the easiest way to answer that question succinctly is that we look to both the SEC and the Department of Justice through bringing its cases to have a deterrent effect on certain behavior. So absent there being such cases, there's always going to be a perception that the law may not be sufficiently effective. So I think at this point, we have to defer to the investigations and see if they result in enforcement actions that in turn will send a message about the level of commitment to enforcement of such laws.
Thank you. Thank you very much. I see no other members who have not been recognized. I'm informed that all members of the subcommittee who wish to participate have been able to ask. Is there any other indication of that? Is there a member of the subcommittee that has not asked questions?
No, Mr. Chairman, but I do have, I'm trying to get your attention so that I could submit an article for the record.
The gentleman is recognized.
Thank you. And it actually fits perfectly with what my colleague from New York was talking about, as well as Mr. Frenkel and others. This is a November of 2019 Reuters article. The headline is U.S. SEC enforcement activity hits second highest level ever in 2019. And the article goes on to explain what the SEC has been doing on enforcement. So I'd like to submit that for the record.
Objection, it will be made part of the record.
Thank you.
Again, seeing no members who have not been recognized, I would like to thank our witnesses for their testimony. Without objection, all members will have 5 legislative days in which to submit additional written questions for the witnesses. You submit those to the chair. They will be forwarded to the witnesses for their response. I ask witnesses to please respond promptly to any such written questions. I think today we've learned that especially during an area of COVID, we need to make sure that insiders don't deal unfairly with the investing public and don't profit from not yet disclosed material information. I look forward to working with my colleagues to achieve those objectives, and hopefully the SEC will not only continue the enforcement efforts that Mr. Huizenga pointed out, but will look at some of the issues brought up by this hearing as to areas that are perhaps wrongful but legal. Without objection, all members will have 5 legislative days in which to submit extraneous materials to the chair for inclusion in the record. I remind members to submit written questions and materials to the record via the email address provided to your staff. This hearing is adjourned.